So anyway, so let's talk about risk. And this is risk from my perspective based on what I'm hearing in the industry and what I am seeing as a risk manager and what's going on out there. And we certainly can't hit every topic, but these are areas that I think are actionable and areas that you may have already heard and things that are coming your way in 2016 that I really think we need to focus on. Some of them are not new, but they're ongoing issues. But I'm hoping that each and every one of you as a leader can take back a concept, at least one, and say, you know, I think I should try and implement that where I'm at because it's going to make things safer for our patients and it's going to reduce risk for all stakeholders, the providers, the group, the hospital, anyone else who could be named in a claim or a lawsuit. All right, are you ready to jump into this? Yes. Okay, I have top 10 here, but I actually threw in 11. So we have a lot of ground to cover in 30 minutes or less now, so let's jump into this. First thing is from Diedrich Healthcare. Now this is their 2015 report because no one has released closed claims analysis for a 2016 report yet that I can find. So that means this information is important, but it's based on 2014 claims. The most important piece of information here is that we are trending up. You look at the early 2000s, we were up high, we started to trend down, we're trending back up with the amount nationally that we're spending on professional liability. Not expenses, but indemnity paid out on behalf of providers, which are clinical providers, hospitals, skilled nursing facilities, all of those. Anybody who bills for services that way is a provider. So we are now at about $4 billion for 2014. That was a 4.4% increase from 2013. I expect that trend to continue, and as it continues to rise up, what's going to happen to commercial insurance rates for all of you and all of us? They're going to trend back up. They're at a very low place right now. If you're really, really smart, you'll secure longer-term deals with your insurer to make sure that you don't have significant increases in your rates going forward, provided that your risk history will support that type of an arrangement or agreement. You can see some of the states that have gone down or up. I love the North Dakota, South Dakota thing. So North Dakota, their total amount paid out for the whole year, the whole state, for indemnity was $762,000, a drop of 82%. I mean, $762,000. Some of these other states, that's professional liability budget dust. For some groups, that is. It doesn't even register. And then you've got $20.3 million in South Dakota, and that increased substantially, 196%. Wow. I mean, I know what happened. Maybe the people from North Dakota went south to South Dakota for the better weather. I'm not sure what happened, but something crazy happened. But there's some demographics for you. The most important information on this particular slide are those high-risk areas, and they're color-coded. So the first ones are going to be those that are really high. $300 million for the state in indemnity paid out or more. And what are the two high-risk areas in the nation? Hey, if you know your geography, we've got Pennsylvania and New York State. Not just New York City, not just Philadelphia, but those entire states. Very high risk with the amount of indemnity paid out. The second category in pink, we've got a lot of places that are giving us trouble. New Jersey's thrown in there, South Florida, anyone from Miami? No. Great place to live, but a very, very difficult risk management climate. It really is. You look at California and Texas, they're listed in that range, but when you look at per capita dollars, they're not really even on the list because they have such a large geographic footprint and also a huge number of people. So when you break this down per capita, look at New York State. For every man, woman, and child that lives in the state, the amount that they paid out in 2014 for indemnity, if everyone paid into it to cover that indemnity, it would have been $36. Imagine that. Most of those people didn't even seek medical care. That is a huge amount. You know, I don't have the additional information here on the low side, but North Dakota was $1 per patient that lives in the state. Not per claimant, but per entire population. Pretty low. If you want to almost completely eliminate your risk, you got to go to North Dakota, and you got to like snow. Okay? All right. So when we look at payment allocations by malpractice allegation, misdiagnosis is by far and continues to be the most likely area a third of the time. When we look at dollars spent on severity, and it's almost always, well, at least a third of the time, most commonly is going to be wrongful death. Misdiagnosis leading to wrongful death. When you look at individual clinical entities, however, those who survive a neurological complication or problem. So people who have quadriplegia, brain damage, and they need long-term life care, And the economics of that are such that, that the claims are very, very expensive. So the average indemnity paid out for one of those claims is $944,000 nationally. So that should be putting everyone on notice that that's nearly everyone's policy limit in this room, $1 million. And if that's the average for these neuro claims for people who survive, that's scary. And also for neuro claims, there's a 50-50 chance for a defense verdict if you take it to trial, where other types of cases, it's 80 to 90% that you're going to get a defense verdict. And so you don't want to play around with neuro claims. They're very, very dangerous, and they can be very, very expensive. All right, we'll keep moving on. So our workforce and advanced practice providers or advanced practice clinicians, whatever terms you're using, and supervision. Anyone struggling with the concept of supervision? Okay, at least a couple of hands. You just, this side of the room is just completely fatigued at this point. You're just done. Well, I'll just consider your lack of participation as passive acceptance. And I think it's an issue for us. And what I have personally seen as well, that a lack of supervision has taken over from over-supervision, where we wouldn't allow any autonomy and wouldn't allow them to practice to the scope of their license or training. Now we're so happy to have help, we just let them do whatever they can. Somebody has a lab coat, somebody has some sort of a license, and yes, you have a pulse, please go to the rack and see whatever you want to. That's happening in some places. We need to bring some construct to this. I tried to define some of this in an article a couple of years ago, and basically it defines supervision. PAs compared to nurse practitioners, PAs by definition and based on every state regulatory statute that's out there are dependent practitioners. That's not meant to be negative. They're dependent. They're not going to practice autonomously. They have to have a supervisory agreement. Nurses, on the other hand, most states don't require the corollary, which is a collaborative agreement. But when they work in the emergency department, we're not going to necessarily have people work autonomously because that's not the way it really works in most emergency departments. So are we going to have autonomous practice? Probably not. We can have indirect supervision. Sign the charts later on low acuity visits, and if there's a problem, then you can contact the patient. That is acceptable in some situations. Consultation. The PA or advanced practice nurse wants to talk to you about a case. You can then decide if it's important enough that it needs to be documented, that interaction, or whether you're just giving guidance that doesn't need to be. And no consultation, as you mentioned, you're giving indirect supervision, which later you would review the chart because it's such a low acuity visit you deem that they can handle that almost autonomously. And then direct supervision. We touched on it the other day, but face-to-face time. If you're going to bill at 100% the physician fee schedule for Medicare as well as some select third-party payers on the commercial side, you're going to need to do that, but also do you want that for certain patients? I think you want that for certain patients, and I think our advanced practice providers want that level of support. You need to verify procedural competency. Just because they say they can do it or you want them to do it doesn't mean that they've been properly trained at baseline training, and then they're competent to do the procedure. What many state statutes say about scope of practices, that is deferred to the supervising physician, whatever they want to do. And then what do? Do we handle that responsibly? Not necessarily. What do a lot of hospitals do with credentialing? Well, they also follow the state statute that says, let's go ahead and defer that to the supervising physician. And what does the supervising physician do sometimes? Hey, you want to do an LP? I don't really want to do them anymore. If you're here, I'll show you one, I'll watch one, and you're on your own. Maybe that works out okay, maybe it doesn't, but it should be written in policy. What patients our advanced practice providers should see, what they can see almost autonomously or not. When do they need to get intervention with the physician? What procedures can they do? And we need to stick to the policy because any policy is a double-edged sword. If you have a policy, it helps you. But if you have a policy that you don't follow, it's worse than not having a policy at all. So make sure it's a policy you can live with. All right, so hospital credentialing, I just want to throw this out to you from the Joint Commission, and CMS supports this as well. If your advanced practice providers are providing medical level of care, which means they can go see a patient and make medical decisions, it's not maybe or kind of or sometimes. The Joint Commission says they must go through the medical staff credentialing process. So they should have a delineation of privileges form, they should have core privileges, they can have add-on privileges they can apply for if they have the right training and competency is verified. I'm still hearing that a huge percentage of hospitals do not do this. They defer to the supervising physician, which does not comport with what the Joint Commission wants or what CMS says is necessary. All right, I've got a case. Do you want to hear about a case? Or we can just skip through it. It's a sad case, so if you're having a rough day, I don't recommend listening to this. All right, so let's talk about it. This is a case about a couple things. A clinical entity that's important for all of us, and also it's about supervision and what we should do, and it illustrates how we need to define this better. Okay, ED visit 1. Whenever you're in a risk management discussion and someone says ED visit 1, that's not good, because what's coming next? And what after that? Yes, so ED visit number 1, June 7th, 67-year-old female, ankylosing spondylitis. Is anyone worried yet? Yes. When I hear that in somebody's history, I look in my bag for the next pair of underwear. That is a scary diagnosis. So a slip and fall strikes their head, diagnosed with a C7 fracture, admitted for 6 days, discharged with a hard collar on. Is everybody okay with the care delivered here? I didn't give much information. No, you're not good with it. Steve Davidson, you're just a hardcore man. What would you like done differently here?
Well, frankly, I don't know that a 67-year-old in a hard, rigid collar is able to care for herself.
Good point. So can a 67-year-old discharged with a hard, rigid collar, can they care for themselves with this background and history? Maybe not, but not discharged from the ED. They were discharged for their inpatient stay. So we're going to hope that case management was involved and home health if they needed it, but you're exactly right. Let's do the right resources. But that is way off topic. But since you're such a smart man and a learned doctor, I wanted to make sure we got your opinion on that. And you're going to have some issues coming up here. ED visit number 2, 10 days later. Patient presented at 0020. Why do patients come to the emergency department when it's inconvenient for us and for them after midnight? Just to inconvenience us? That should be a red flag. So worsening pain and out of pain meds. So what do? Well, you want more pain meds? We'll treat the pain. Are we thinking about why? Discharged at 1 a.m. and just a curbside consult with a physician. Hey, this is what I have. I'm going to prescribe some pain meds. Do you think that's okay? It seems fine. Go ahead and do what you want. Do you think that's appropriate? You were just so aggravated by this case. Someone needs to come sit by Steve, or distance yourself. You need to get a radius around you. He's going to blow when this case evolves. Take a look at June 17th. What do we have in the initial triage documentation? Well, the eyes are working, so that's good. Sensation is decreased and a cool extremity, but that was no change from previous. It was good that they noted that. But then what do we also have here? Well, we have a discrepancy in the record. We have sensation normal in the same record. That's a problem. That's a nursing and other provider discrepancy. So, ED visit number 3. So the patient awakes with pain, 8 out of 10, weakness in right arm and leg and difficulty walking, history of AFib. You know what? What's in the record is, oh my gosh, this must be a stroke. Let's do a CT scan of the brain. So it's 10 o'clock in the morning when this patient initially came back to the ED. What is in the triage note? Status post C7, C8 fracture. How are you going to present that information to a jury of lay people? I would love to see the person who wrote this explain to the jury where C8 resides. It doesn't exist. That's a problem. That's a problem. And take a look at this. So we've got numbness and we have tingling. And what do we have here also? Also listing in the extremity exam, hey, it's a right arm is weak. But when we do the neuro exam, everything's intact. And that's the same provider. The providers aren't agreeing, and the providers aren't agreeing with themselves with the multiple voices in their head. This is a problem. Look at this. And now you can see we're going down the path. Ooh, we've got a pronator drift. We have altered light touch and 2-point discrimination. What do they think this is without considering other possibilities? It's a stroke. They decided it was a stroke from the very beginning. So, CT scan of the brain is negative. Neurology is consulted. They say, you should get an MRI of the brain and the C-spine and consult neurosurgery. That all works out great until we realize that radiology decided not to do the MRI of the C-spine because there was too much pain, and they didn't tell anybody. So the MRI wasn't done. The physician was not involved in this visit. The patient gets admitted, and this is the diagnosis, CVA. This was an accident, but not a cerebrovascular one. This is bad. Steve, you okay? You hanging in there? He's not good. He's sweaty. He is. Okay, the outcome. After a return from MRI, incontinent of stool and urine and paraplegic. Bad outcome. Transferred for surgical decompression and fixation. Died 4 months later due to complications. I think it was sepsis from decubiti and pneumonia. Bad deal. So where are we at with this case? Claims, 2 PAs, hospital, and the neurosurgeon. This was actually settled on behalf of the 2 PAs for $925,000. Do you think that that's a reasonable, at least financial outcome when you look at claims management? Yeah, I think this was an avoidable miss that really shouldn't have happened. This is a patient safety issue. So supervision could have helped this. Square peg into a round hole, this is not a CVA. You're ignoring what happens with ankylosing spondylitis. The eye does not see what the mind does not know, and I don't think the providers involved really understood ankylosing spondylitis. Supervision. If there are repeat visits, I think the doc needs to be involved. High acuity, get the doc involved. Nursing provider discrepancies in the record is an issue. There was no documented discussion with the physician, and when you get their deposition testimony, what do they say? The PA says, I never spoke to the doc. And the physician says, I had an extensive discussion. Well, who's right? It doesn't matter, because now you're pointing fingers at each other, which just creates more exposure for liability. So testing responsibility, let's make sure the tests that we order are actually done. Let's follow up on that. Let's talk about ankylosing spondylitis, a great article here, and I'll just share some take-home messages with you. This article, they say, it underlines the importance of systematically searching for fractures in cases of ankylosing spondylitis with even minor trauma or when faced with a recent exacerbation of spinal pain. 0020. A recent exacerbation of spinal pain. Why are they out of pain medication? Because they were hurting more and they took it all. And it still didn't work. What about this? A spinal cord injury was detected in 47% of the cases and was found alongside cervical spinal fractures in 88% of the cases. The neurodeficit can be acute or delayed. This is describing this person. Yes, doctor.
So Kevin, thanks for the article.
You're welcome, Steve.
But I would argue that the emergency doc doesn't need to know what's in that article. What the emergency doc and the PA need to know is that they need to call the previous treating inpatient doctor and say, your recently discharged patient now has worse pain. What do I do?
Do you feel strongly about that, Steve? Yeah, I think you're exactly right, and I'm glad you brought it up. I'll differ slightly in the opinion. I'll back up and get out of your way. But I agree, they should, because that would solve it. But they did contact, neurology. They wanted to have this consult and wanted the right things to happen, and it didn't. It didn't get carried out the right way, but I would differ in my opinion slightly this way. You need to know this. When you're taking care of somebody with ankylosing spondylitis, you need to know when they have an exacerbation of pain or a recent fracture, there is a really good likelihood at some point they're going to have a neuro complication. And if they're even thinking about having a neurodeficit or a neuro symptom, you need to be imaging them. And I think there's some good take-home messages there. And also with supervision, it's important. Define the supervisory relationship with APCs or APPs, complex cases, get the docs involved, make sure that you document the interaction, no square pegs into round holes, and you got to know about ankylosing spondylitis. And always in neuro complaints, have a thorough neuro. Always do that. All right, let's move on to the next topic. So is there a doctor in the house? Any of you respond to in-house emergencies, or do your departments require you to do that? Okay, good. Over now, these people are awake, and now you have fallen asleep. Anybody over here? I think there were a couple. All right. Oh, thank you, first couple of rows. All right, so a couple things you need to be thinking about. What is your primary responsibility and what is your contractual responsibility to the hospital? Are you given an exemption? Can you abandon your patients in the ED to go to an in-house emergency? Or should they be sent to the ED so you don't have to do that? Do you have an opt-out, meaning there are too many patients in this ED, or the acuity of the patients that I currently am caring for in this ED are too great for it to be safe for me to leave because I'll be abandoning them and I'll be violating my contract? Yes, it has happened when the hospital wants you to go to the floor to look at somebody who fell out of bed or to manage an airway in the ICU, and there's a bad outcome in the ED, the hospital holds you accountable for leaving the ED. Because that's what your contract says. So know what your contract says. Are you a good Samaritan if you do this? I've been waiting for years for the case that would test this. So if you don't bill for going to the floor, that means you don't have duty, right? So you can defend yourself as a good Samaritan. Does anyone agree with that? Based on the way I've said that. No one should be raising their hand. Well, for a long time, that's been a defense theory, and it doesn't work. You look at Illinois, this opinion was filed by the Supreme Court of Illinois, March 20th, 2014. And this is exactly what happened. There was an airway emergency, doc went up and managed the airway, there was a bad outcome. We'll leave it at that. And what they basically said was, no, the Good Samaritan statutes were an attempt to protect volunteers, not people that are taking care of patients within the scope of their practice and while they're getting paid. Person was getting paid to be in the ED, but they were up in the ICU. They said, no way, this is precedent setting. Don't think you're going to get a successful Good Samaritan defense if you're at work and then help somebody. Because duty is about whether you have an obligation, not about whether you get paid. Getting paid is one way to establish duty. But you had an obligation to go, and that's very, very clear. What about other forms of Good Samaritan problems? Does anyone ever ask you in your department for care? Can you look at my ankle? Can you look at my ear? A neighbor, a friend, has that ever happened? Yeah, it's a problem. Here's a very good example of what can happen when we work basically with our family in the ED. So it's the hey doc. Here's an ED RN coworker that says they have a good working relationship, worked together for over 5 years. She asked for a prescription for her son, who she believes has another otitis media. Amoxicillin works well. She doesn't want to miss the next couple of shifts she's working to take the kid to the doctor the next day. And what does her friend say? Her coworker, her colleague, her compadre? Well, of course I will do it. So what happens? The follow-up on this is the prescription is filled, and allergic reaction 24 hours later, and 12 months later, a lawsuit is filed. So what does the medical record say? Yeah, how do you defend this? You can't. There are some commercial insurers that will say, this was out of the scope of your coverage. Normally you take care of people in the emergency department. Normally you document your care. Normally you do a thorough evaluation. We're not covering this. That could happen. It could happen. So there's no documentation. You can't do really staff favors. Don't charge them, but say, listen, the hospital or we or the group or whatever, we really have to have them registered, but I can't just take care of you without documenting the care. So neighbors, friends, be careful. And this one I'll share with you as well. It's, I think, an important concept. If anyone is volunteering their time or even getting paid to work for a sports team, like a local school or high school or something, when you travel across state lines, you are licensed in Indiana, but the football team has a game in Illinois, and you enter the field in Illinois to take care of an injured player, and you administer care to them. If you don't have a license in Illinois, you are now practicing medicine without a license in that state. That's a real problem. If you get called on that, you will be in jeopardy. And that's what this article says. Lots of great information about that. Be careful. Trying to do the right thing and be nice to people, if you don't understand the landmines you can step on, can get you into real trouble. All right, so policies and admission orders. Anyone writing admission orders? Yeah, you got to be a little bit careful with that. You know, this basically is from a performance improvement group, and there were a couple quotes when they interviewed this emergency physician. He said, working in the emergency department is like driving a nitroglycerin truck. I do not know what a nitroglycerin truck is. I do not want one. It does sound really bad, but I kind of understand the corollary. And ED physicians are oftentimes asked to write admitting orders to help their colleagues out, is what he said, but the old adage is, you know, good deeds don't go unpunished. That is true. When we're writing admission orders, when are you going to go check the patient on the floor? When are you going to do that? You've enabled the person to not go check on the patient. So if something bad happens from the time you've written admission orders to the time that doc assumes care, you're responsible. And you were never intending to go see that patient on the floor. That's risky. You can write a transition order, admit to Dr. So-and-so telemetry, diagnosis this, but no medical orders would be the best situation to be in. And if you have hospital policies and you follow them, you're really going to be well protected. When you don't follow them, as I mentioned earlier, you'll get into real trouble. This may be helpful to you. CMS sent out this regulatory update in 2014 regarding the 2 midnight rule. Basically what they said was, when you write the admission order, that's the beginning of the certification process for the admission, that it comports with the statute and the 2 midnight rule. You are verifying, if you write the admission order, that it meets all the requirements for an admission. Can you say that as an emergency physician? I can't. And what they also said, it's okay to write it as a verbal order as long as then someone documents in the record somewhere that the verbal order was taken and by whom. That is what we should be doing, because we should not be certifying whether somebody's an admission or not under the 2 midnight rule. This one is interesting, just about hospital policies. It was a recent case, and this actually was a jury, a court judgment in favor of the plaintiff for $6.9 million. Let me tell you roughly what happened. Patient comes in with obvious stroke symptoms. Seemed like an MCA distribution stroke. It resolves in the ED. What do you do with people who have TIAs that resolve in the ED? You admit them. Did you call neurology? We had somebody here, but it's completely resolved. Would you normally? Some places would, some places wouldn't. Well, the hospital policy said that you should call the neurologist when there's a stroke. The patient had a stroke 24 hours after admission and had a really bad outcome. So what they said was, do you know your hospital policies and why didn't you follow it? And a jury of lay people said, well, it was a stroke and you didn't call the neurologist. This policy didn't say when it's a TIA and it's resolved, you call the neurologist, but the jury of lay people hears, it was a bad outcome because of a stroke and you never made the call. And the question for the defendant is, did you ever call the neurologist? Well, I'm not supposed to. That is not the question. Yes or no, did you call the neurologist? And why don't you tell the jury your answer? Because I already know it. No, I didn't. That's how you end up with this kind of crazy excess limits judgment. We have to make sure our providers understand the hospital policies that bind them to the care and be aware of that and know how to answer questions about it. Are they authoritative? No, they're good guidelines, but there's room for individual decision making. You have to be able to answer those questions properly. What about patients who go home after we medicate them? Okay, so you want a couple of Dilaudid? No problem. You got 2. You're still having pain? There's 2 more for you. You ready to go? I've heard many places say, we can't release them until I see their ride. Matter of fact, I won't even give them the pain medication until I see their ride. I don't know, that borders on unethical because someone's in pain. It is not your responsibility to manage that individual's life once they leave. It is your responsibility to protect the unnamed third party, which means if you just had a seizure or you just had Dilaudid, it's not appropriate for you to drive, you need to tell them you can't drive. You need to arrange transportation. If you see them get into a car, if you want to call law enforcement, you can. You shouldn't be tackling people, detaining people. That is not your obligation or responsibility. You should have policies around this. All right, apology laws. I love apology laws, but they're creating some risk because people are beginning to think that apology laws mean something other than what they really are. They're different from state to state. And apology laws in general are not going to allow comments that you make, anyone makes about a case and say, gosh, I'm really sorry about what happened with your care. They would be inadmissible because we want disclosure of error. And we don't want a chilling effect about people letting others know about what happened with their care. That's the intent. But when providers say, oh, we have an apology law in our state, great. They can pour out their soul to the patient and the family, and it can't be discoverable, right? Wrong. It depends on what state you're in. So there are 36 states have apology laws. There are limited protections in some of them. Here is the list. So some of them just have sympathy only. Gosh, I'm really sorry that they amputated the wrong leg. That's a bad day. That's a show of sympathy. But if you say, I am really sorry we did the wrong thing and it was our fault, in a sympathy-only state, no, what you just said is now admissible. In the states that have no statutes, everything is admissible. And those that will restrict an admission of fault, meaning you state that it was an error and you're taking responsibility for it, that is not admissible. And so you have to know where you are on this map so that you're not making a mistake. Very important information. All right, what's also important is if you apologize prior to the claim, this came out about a year ago in clarification from the federal government. What goes to the data bank? What goes to the data bank is when there's a payment made by a third party for the benefit of a healthcare practitioner and, important, against whom a medical malpractice claim or judgment was made. So if you talk to a patient before a claim or a lawsuit is filed and you have a settlement with them, that's not going to the data bank because there was not a claim or a judgment made. A judgment means when a court decides. A settlement is not in the court. It can be, but doesn't have to be. A judgment means the court and the jury decided this is what they're going to pay. So that's important. Get to people early, and it's the right thing to do. Now, we touched about this a bit at the rural workshop that we did, so I won't spend a lot of time here, but this applies to other places as well. So hospitals' responsibility under EMTALA to provide a call schedule based on the providers and services they have. On-call physician's responsibility to see the patient and follow-up. This is interesting, and we didn't talk about this yesterday. A lot of people think, well, they're required to see the patient at least one time. How many of you have been told that? They're on the call schedule, they have to see them one time. No, EMTALA is silent on that. They are not required to see them one time. The hospital is required to have a list, and they're required to be on that list, and if they're on that list, they are required to respond if you're asking for assistance. They are not required to see them and follow up. Okay, refusal of on-call physician to respond. If you're asking for help and they won't come, you have an obligation to document who the doc was, why they wouldn't come, and their address of their practice and their phone number. I think it's all of those elements. And I think it's helpful to nicely let them know, well, you don't want to come in for this hand injury, you want to send it an hour and a half away to the trauma center. Just understand I'm obligated to list that on the transfer form. Maybe they'll come in. All right. Mode of transportation is the transferring facility's responsibility to decide that, not the receiving facility. You want their agreement, but it's your decision. And helipad and the campus rule, be careful. If you want to agree with EMS that they can rendezvous with aeromedical services on your helipad, have a policy that says they're not hospital patients unless they decide they need to be. Because if you don't define it, then we'll wonder why they were on your campus and they didn't get a medical screening examination. All right. With digital media out there and recording devices, what is happening to us? Well, you know what's happening? People are recording our conversations. Great case of an anesthesiologist and a gastroenterologist who got taped during a colonoscopy, and you can pull up this on the internet and get the details. They said nasty stuff about the patient. He said he hit record so that he would get before the procedure, so he wouldn't miss the discharge instructions. I don't buy that. You know what you were doing. But he didn't miss the discharge instructions, and he got all of this. So it ended up with the jury saying it was worth $500,000. So what their defense was, it was crazy. Well, he didn't get consent of the docs, so therefore you can't. None of this is admissible. Well, they didn't look at which states actually require two-party consent. The two-party consent states are listed below. There are 13 of them. Every other state is a one-party consent, meaning the party that presses the record button. People can record what we're saying in most states and not have our consent, and it will come back to bite us later. All of our providers need to know that. Interruptions, I won't spend a lot of time here, but there are 2 citations where interruptions create errors. This was about observers following attending emergency physicians around and seeing how many times they were interrupted and then a break in task, meaning they had to go do something else. And the data is compelling. So mean number of interruptions, 30.9. In that time period, and which was basically, it was 180 minutes. So every 6 minutes and then every 9 minutes they had to break a task and what they were doing and go do something else. This article we won't spend much time on, but I want you to have it, says this actually impacts negatively experience of care also with interruptions. Stroking out of consent and TPA, you need consent to give TPA, informed consent. And I won't spend a lot of time there, but you have to. And some people say, well, it's the standard of care, so we don't need consent. If we don't have consensus, it may not be the standard of care, but even if it is, how many of your hospitals still get consent for appendectomy? Do they? Yes. Is that the standard of care for appendicitis? It is. So why not get informed consent for this? We absolutely need to do it. Some articles have said we don't need to do this. This particular article said, well, if a patient gives an informed refusal, they weren't adequately informed, because of course they'd want the drug. The likelihood of litigation, yes, people say it's more likely to get sued for not giving TPA than for giving it, but that's because when you look at the data, many more patients don't get it. And if the equal number of patients got it that didn't get it, well then absolutely, then it would be equal and not weighted that way. I will share this with you at some point if you like, but this is a bad consent form that outlines many, many things that say this will help you, this is the treatment that you must have, and you even consent at the bottom to allowing pathology as necessary to do away with specimens that they might obtain and if you need to go to surgery. Why would you need to go to surgery for a stroke? That? And this person, it took them 6 months to recover from this stroke. Steve? No one who has a coronal section of their brain survived anything, just so you know, that's bad. Sepsis. We need to recognize that sepsis is a killer. It's a long-term killer, not a short-term killer. This article looks at mortality rates in all hospitalized patients versus sepsis patients. And if you look at year 5, 43.8% of those who are admitted for sepsis versus 8% will die who are admitted for other reasons. We have to educate our patients, and we have to get informed consent for pressors. Look at all the complications, septic emboli, as well as purpura fulminans leading to limb or digital amputations. Many cases like this, and I won't keep that up very long, many cases, we're getting so good at treating sepsis, they're surviving and that is happening. And now they're saying, we didn't know this was going to happen. We have to tell them. So let's get informed consent, and for pressors, when we vasoconstrict the periphery to preserve the core, we have to let them know, and let's teach patients about sepsis. You're not going to go back to work Monday when you have sepsis on Friday. You're going to have long-term complications. Here's a medical legal case, and we'll conclude here. At 2:16 in the morning, 40-year-old female presented right flank pain, fever, vomiting, temperature of 104. I would ask you, Steve, but we're out of time, so I'm not going to ask you about this if you're uncomfortable. 4:10 in the morning, seen by a physician, that's just too long. The white count is 1.7. Some people might say, well, great, you haven't even mounted a white count response yet. Or it's plummeting and on its way down, isn't it? So the treatment, let's give 4 liters of IV fluids. Is it enough? I don't know. Maybe it is, maybe it isn't. Ceftriaxone, is it broad enough? Probably not. Dopamine at 6:15 because the pressure was 61/41. Is there informed consent? No. Was there adequate volume resuscitation before giving the pressor? I don't know, but it could come into question. Report is called to the ICU at 8:15. 4-limb amputation is the outcome, and a defense verdict at trial. Wow, amazing. But what happened was it was overturned because of a jury selection issue. So then what subsequently happened was it was settled. How many people with a case like that with a plaintiff that looks like the image I showed you, and hers looks just like that, I didn't want to use her exact image, but how many want to go in front of another jury and try that again? No, you don't roll the dice on that, so it's done. So I appreciate your time and attention. I know there's a lot of information, but I wanted to give you as much as I could.